Welcome to the Defense and Aerospace Report. I'm Vago Muradian here in Washington, D.C., where we're covering the Center for a New American Security's annual strategy conference, this year dubbed Strategic Competition Maintaining the Edge. And we're honored to have with us one of the world's leading experts on lawfare, retired United States Air Force Major General Charlie Dunlap, who's now with the Duke University Law School. Sir, it's always a pleasure seeing you. This is an interview that's been a long time in the making, so I'm honored to be able to have the opportunity to talk to you.
Vago, it's so great to see you, and you're always at the center of things, and here you are again, so I'm happy to.
I appreciate it, sir. It's an honor. The only reason I'm in the middle of some of these things is because of smart guys like you that I talk to. You've been looking at this space, this sort of hybrid space, short of war, where great powers, China and Russia in particular, but also a lot of international organizations, you could argue terror organizations as well, are trying to use the rules-based global legal system in order to try to undermine, or at least advance, not only advance their interests, but also in some ways undermine that rules-based order, right? For example, China's island building in the South China Sea was utterly confounding because the international community didn't know how to respond to construction on disputed islands. Talk to us about what the state of the art is, as somebody who is expert at watching this space. How is this space evolving? And I would put a second question to that, which is, how should the United States be exploiting or stymieing what its adversaries are doing?
Vago, you're very correct. These adversaries are using a process, strategy, so to speak, that I've called lawfare in the past. In other words, they're trying to use law as a substitute for traditional military means. And what's particularly interesting about what's happening today is that they are using it to coerce results without breaking the threshold, the legal threshold of what some people might call an act of war. It's a very sophisticated kind of strategy. For example, the Russians are very expert in international law, and when they moved into Crimea, they used the language of international law. They used the Kosovo decision of the International Court of Justice of unilateral declarations of independence. They used a process called passportization. They really try to frame it so that there are people out there who are going to believe that sort of thing. So in other words, they use it as another way of advancing their interests and precluding us from responding in a way that we might have responded had it been a more traditional kind of thing. Chinese are very much on this, and in fact, it's part of their actual strategy. It's one of their, what they call three warfares, one of which is called legal warfare. And what they're trying to do, for example, in the South China Sea, is create facts on the ground that will influence the legal designation of ownership of that area. Even though under the UN Law of the Sea Treaty, the arbitration panel found against them, they have just published within the last 2 or 3 months an enormous book of law review articles, in essence, countering everything in that adverse decision that they got. So what they're realizing now is they can avoid this confrontation with the military superiority of the West and of democratic nations by tapping into, in essence, weaponizing law, because they know that the West respects the rule of law, so they're trying to manipulate it to their advantage. Now, I don't want people to walk away with the idea that law is bad or international law is bad. No, it's a good thing. It's just that we need to get smarter at it.
And so what are some of the ways that the United States should be thinking about the problem? I mean, you've been working this issue for years. You were actually in uniform where you were highlighting some of these challenges. You were one of the key Air Force lawyers that was participating in the legal and intellectual process at the time. The United States was with each strike advancing the boundary and the definition of what was, a legitimate warfare against what were illegal combatants, non-uniformed combatants. So talk to us about some of the things and the ways that the United States government needs and its allies need to think about this space.
What we need to do is look at it as a strategy, and it needs to be formally incorporated into our strategies. I was over at NATO with the Germans last year, and they're starting to think in those terms. In other words, we have to incorporate this into our planning along the lines of how is the adversary going to try to use the law, and how are we going to counteract it? A lot of these issues, for example, in Crimea and the Ukraine, it's hard to get the West official legal position on it. It comes out piecemeal. That's not the way to deal with these kinds of challenges. You need to have a formal process, and you need to go into all these conflicts or adversarial, confrontations with a good idea of what the law is. And then you need to let the people know what it is and react in a timely manner. The problem with the West is that we go through this long process of deciding what our position is going. Meanwhile, adversaries are getting inside the decision loop in legal matters. So in other words, the law isn't really the enemy. It's our slowness in reacting to what the adversaries are doing, and also the lack of planning. So that's what we need to address.
Let me ask you the question of free societies, though, right? If you look at what the Russians are doing, for example, if you particularly go to the southern flank, whether it's in Republika Srpskaya, whether it's in Macedonia, whether it's in Montenegro, you talk to folks across the Balkans who talk about how Russia is taking advantage of every legal means in order to often undermine those societies. We've seen that across Europe, whether it's ultra-liberal parties who've gotten support from Russians through very, very legal means of contribution. Le Pen is one of the people who benefited from it. There's even evidence that Brexit benefited from a lot of Russian money because it would be disruptive for the EU. What can free societies and how do free societies need to look at their own laws? You want to stay open and free societies, but what are some ways that governments can tune their laws, which are for law-abiding people, and not be conduits to a foreign power or foreign powers? Same issue goes in Asia, where there's some evidence China supported Duterte in part because of his disruptive strategies. Talk to us a little bit about what societies can do to indemnify themselves from this sort of foreign intrusion that's designed to be an undermining factor.
Vago, you're exactly right. And here's what needs to be done. We need to think proactively instead of reactively. What we've done is just react to these things after the fact. What we need to do is to red team, in other words, sit down and look at our systems as they exist and figure out how is an adversary going to try to turn a wonderful thing like the rule of law into a club that they're going to beat us with. And so in other words, if we sit down and plan and are able to evolve the law as necessary, but also to react with it with a lot of transparency, I think that people, if they're given the right information, then they will be able to deal with these efforts in the right way. The problem now is when countries and NATO and organizations dither with coming out with a position, that's what the adversaries are going to exploit. For example, there's international law as to what is a use of force in cyberspace, but we don't have countries coming out and saying, we consider this a use of force. Doesn't mean you have to go to war, but at least we'll establish the norm that we are calling this a use of force. We are considering this an attack under Article 51 of the UN Charter, and we will decide how and when we'll respond. But at least then people know this is a red line, and there's a lot of clarity. So I think that that's a big part of the answer, is just using, the West is a Saudi Arabia of lawyers and law. Then we ought to start using that resource proactively instead of simply trying to react after the fact, because we're going to be always racing to catch up with these adversaries. And it's a mistake to underestimate the sophistication of the legal capabilities of China, Russia, and other adversaries. And we haven't even touched on how non-state actors are manipulating the rule of law and so forth.
Well, so to bring that around to that issue as well, it's a two-part question. How are non-nation states, right, non-state actors using this space? And from your perspective, having watched this space for a while, where are we going to be 5 or 10 years from now if we're not getting our, where are they going to be 5 to 10 years from now? So two-part question, non-state actors, but where's everybody going to be 5 to 10 years from now?
Well, a couple of answers to that. Number one, non-state actors look at our laws, look at our rules of engagement, and study them very carefully, and they look to exploit them. Part of our problem is in reacting is that people don't really understand what the law is. And efforts by the West to try to satisfy people have backfired on us. For example, you might be aware the rules of engagement that were publicly disclosed that said that if there is one civilian casualty potential, then we won't conduct a strike. Well, that telegraphed to the enemy exactly what they needed to do, so they've surrounded themselves with civilians, which I think is one of the reasons why we've seen this upsurge in human shields. The law, of course, is not that. It only requires that casualties not be excessive in relation to the military advantage anticipated. So we need to have a lot more clarity with that. 5 years from now, what we're seeing is the extrapolation and the leveraging of technology to use that form of lawfare to an even greater extent. What we're going to see is people are going to make up what looks like a video of a war crime, for example, and it's going to be very hard to detect given the technology that's coming out. And so we're going to see that trying to influence publics, because in democracies, it is still the fact that even a well-intended, conceptually correct operation will be undermined if people think it's being carried out in an unlawful, iniquitous, or inhumane way. And that is, a long-standing understanding in the law. So we need to really jump on this, and we need to formalize the process of the fact that our adversaries are using this. And I'll just give you one other example real quickly. Remember the little green men? Well, people are, oh my gosh, can we do anything about that? Well, the law does have answers for that. And they just need to bring that expertise to bear and do it quickly and have the same kind of reaction, the same kind of focus and sense of urgency that we would bring to a kinetic attack, because these non-kinetic methodologies can have just as devastating effect.
Well, so, you said that that's legal because there was this sense of, oh my God, we can't respond because we don't know how to respond. But you're saying, actually, we could have responded. How should we have responded to whether it's little green men or little blue men that both of these adversaries are trying very cleverly to manipulate? There's enough doubt. You don't really know if we're Russians. Talk to us a little bit about what we can still do under the law.
Well, let me give you, from a legal perspective, I think step one is that we ought to say what it is as a matter of law. Then we can let the strategists and policymakers make a decision on that fact. But when we're wringing our hands as to whether it's legal or not legal or what the law is, that is going to delay any kind of response by the people who should be in a position to take those actions. So we have to have as much of a reaction as our adversaries have in creating these conundrums. Now, here's part of the problem. Like everything else in strategic thinking, there's a certain amount of risk. People are going to make legal decisions that are going to be wrong, and sometime we might have to walk them back. But, dealing with these kinds of adversaries requires taking on some risk by decision makers, and relatively speaking, I'd rather be wrong in a courtroom than on a battlefield. So I think that we've just got to focus on this and make it a priority and incorporate it into our thinking. We're starting to see that now, at least in the NATO setting. That's why NATO sponsored, it's not an official NATO document, but the Tallinn Manual on Cyber War. So there's this starting to have this recognition. We just need to accelerate it.
One last question. You are somebody who's expert on that line, those fine lines between law of war, what is warfare, what's not warfare, what's legitimate, what's not, and how existing law can be interpreted. How do the laws of war need to be changed or reconsidered, especially if you include cyber operations? In conference after conference, when you even talk about China, there's a big debate about whether there's going to be any kinetic action even at that front end, or whether or not action is going to be manifest by turning every traffic light in Washington green, shutting down power to hospitals or water grids, and then just allowing actually populations or across 10 or 15 major metropolitan areas, and then have the population sue for peace or cede in some way. As you look at the laws of war, and you look at cyber, and you look at all of these other challenges, do the laws that we have now work? Do they need to be tailored, modified?
I think that the existing architecture of the law of war is sufficient. But here's the problem, Vago. People are going to have to make decisions about facts. So in other words, the law, especially international law, is very broad because it talks about what is the equivalent to an act of violence. Well, some people say, well, how do you do that if the lights get turned off? Well, if lights get turned off, people are going to die. So, but you have to make that decision, and that's what I mean by norm building. In other words, when governments start saying, we consider that equivalent to a kinetic attack, then the international community, the way international law develops, you now have a norm coming to develop that if you do that, then you are subject to everything that the law permits a country to do in self-defense under the UN Charter. So that's what we need to do. And part of the challenge is understanding the facts. There's a technical challenge with attribution, but that's not really legal problems. That's more of a problem with the technology and then people willing to make a decision based on gray facts sometimes. But as you know, Vago, in the kinetic world, in air operations, commanders are always making decisions based on imperfect information, and that's the way I think that we need to look at some of these emerging challenges and have the courage to make decisions. And remember, characterization of something as a matter of law doesn't dictate that you have to do something in response to it. It may be a whole range of things from nothing through war, but at least characterize it correctly so that the norm can develop as it should.
Well, and speaking of norm, one last question, because you opened up a question that we discussed actually just before the interview, which is, so how should the international community have responded to island building by China? At the time that it happened, I mean, I remember I was at the Shangri-La Dialogue, some bags of cement and construction equipment were dropped off and a light put on it, and everybody said, well, I mean, come on, that it's really not going to go anywhere. And now it's not only gone anywhere, but there has actually been that militarization that everybody expected was going to happen. I see this from a U.S. Air Force perspective. They're fixed targets and I can take them out. So we're less concerned about that expenditure of resource perhaps than we would have for DF-21 sites in the interior of China and mobile launchers. But how should the United States and the international community have responded to that and should respond to it, given that it's something literally quite almost out of a James Bond novel?
Well, for starters, the United States should ratify the UN Law of the Sea Treaty. The military's wanted that for years. There's been some, political aspects to it, but we need to ratify that so then we have a seat at the table. Secondly, what's going on now, I think, is the right thing. In other words, they're doing what's called freedom of navigation operations, where they are sailing in an area close to these installations on features that if they were actually lawful, you could not sail in that way through that area of the ocean. And we're being joined by some partners. In other words, I think Australia and the Brits and so forth, that's what we need to do. We need to make sure the Chinese know that they have not succeeded in establishing legal facts on the ground. I'm not talking about declaring war. I'm talking about preserving the rule of law as it exists in international law today. And so those are the things that we need to accelerate, and we need to say at every opportunity that it's not accepted. And we need to look for other opportunities to hold the Chinese accountable for these violations of international law and not observing the ruling of the tribunal and so forth.
Retired United States Air Force Major General Charlie Dunlap of Duke University Law School. Sir, it's always a pleasure.
It's always a pleasure to see you, Vago. You're the best of the best, my friend.
Thank you so much, sir. It's a real honor. Thank you.
Thanks.